the first to know Nsem-Pii TV.
Dr. Kessel ato Forson edina court ni nyina ene se yese wabo oman ne ka 2.37 million euros na Dr. Kessel ato Forson through the proceedings ade say Dr. Kessel ato Forson etimi ekokopie mu e court of appeal a ono ekoye appeal na Dr. Kessel ato Forson na lawyer for aye appeal 2 times. First one ya na second one we there e come here say Ay3su de ama Dr. Kessel ato Forson na yenhwe first one or the koko pie mu court a court no ebogu and the second one there baby a nyoma akeka akone there say Dr. Kessel ato Forson na lawyer for anhwe ye dia ebia efiase ebebem first one no ene dia he or say the court of appeal has in unanimous judgment thrown out an appeal filed by the first accused in the fake ambulance trial, Dr. Kessel ato Forson, in which he alleged that the charge brought by the Republic against him were defective. Dr. ato Forson had contended before the Court of Appeal that the charges of willfully causing financial loss to the state and intentionally misapplying public property preferred against him by the state were defective for failing to disclose sufficient particulars. However, in a ruling delivered on 8th June 2024, the court constituted by Bright Mensa J.A. presiding Batel Kojo J.A. and Amaliboba J.A. dismissed the appeal as without merit. Nti Dr. Kessel ato Forson de koko pie mu e court se kwadu no a oman no e de abono no se ono otena se a ohu se kwadu no a oman no e de bo no enya ade se eno eye defective. Nti se nke betimi anka court of appeal enhwe na nka yentimi enjai asem ni die because ono onim se asem no onye eboni bia ewo nanso ekopie mu ewo court of appeal no wonso etena ase eno hu se Dr. Kessel ato Forson asem na ode beto won anim no enya ade se nsuo bia ejina mu enti won dismissal appeal no as without merit. Dr. Kessel ato Forson ama no anso ha osan ekoso ne na lawyer for ASA. The appellant Kessel ato Forson had initially filed an application at the High Court seeking to strike out the charges and failing to disclose sufficient particular to warrant the trial proceeding. The High Court dismissed same. Followed the dismissal, lawyer for Ato Forson filed an appeal alleging, among others, that the High Court judge erred in holding that particulars of offenses of count 1 and 5 contain sufficient information on the specific act engaged in by the first accused or appellant that manifests without the cause and authorization as contained in count 1 and 5 of the charge sheet. The appeal came on for hearing and was vigorously contested by the Attorney General, represented by a principal state attorney, Richard Jambibi, who argued that the Republic has discharged its obligation required by law in putting together the charge sheet. He contended further that in drafting the charge sheet, they had in mind only the alignment and elements of the offenses with which the accused are charged, as the Republic was required to do. Until Dr. Kessel ato Forson, yedi nkan etro baako na etotwene na won esan faale baako ede koko pie mu ewo the High Court, eno nso High Court no esan ebotugu enokra de na ose kwadu no ayede bebo no enka ebi wo ho a enka yenyim film because na kwadu no edoso nanso High Court eka se nsem na Dr. Kessel ato Forson na lawyer Forson de aba High Court no eka me ese no nso ahodi nim eno nso High Court no enso etimi ebo edito twene this they had done, and therefore the charges preferred against the accused persons were proper. The Republic, according to the Court of Appeal, broke down the charges brought against the accused persons before concluding that the charges were properly filed. The Court of Appeal, in its judgment delivered by Battles Kojo J.A., analyzed the rules of the Court of the Appeals as well as Ghanaian case on what constitute a proper charge. The court observed that in the appeal brought by Forson, the problem he had with charges was with an expression without due cause and authorization. The court stated that it was of the opinion that it was wrong to isolate phrases or words contained in a charge sheet and claim that those words are vague or do not contain sufficient meaning. It is one of the cardinal rules of interpretation in our profession that documents should be read as a whole when being interpreted. The court held that with this in mind, what the appellant should be concerned about is Kessel Forson between August 2024 and April 2016 willfully caused financial loss to the Republic by authorizing irrevocable letters of credit valued at 3,950,000 euros to be established out with payment amounting to 2,370,000 euros were made to Big C General Trading Limited of Dubai for the supply of vehicle purporting to be ambulance without due course and authorization, and Kessel Forson in 2014 in Accra, in the Greater Accra region of the Republic of Ghana, intentionally misapplied the sum of 2,370,000 euros being public property by causing irrevocable letters of credit to be established against the budget of the Ministry of Health in favor of Big C General Trading Limited, Dubai, for the supply of vehicle purporting to be ambulance without due course and authorization, and not just words without due course and authorization. Having examined the charges under scrutiny, the Court of Appeal finally held that the charges brought against the accused persons in fake ambulance trials contain sufficient particulars as required under the Article 19, Clause 2D of the 1992 Constitution and Section 112, Clause 4 of the Act 30. Dr. Forson was represented by his lawyers, Dr. Abdul Basit Aziz Bamba. Intimino Elkasedi Elkamia is a high court, and so in some Dr. Kessel Forson at the court
2.37 million euros ambulance case. I met Dame in Kolondi's house, Jakpa, and Aka. Now, okay, can't sorry now, go on. I send row call to Kudia dance here. I say, Oshia Gofre Dame. Ewat justice yeni Kolondi fee empre 9. Na nyidi kan Oshia no. Ono na a request here. On say na no press conference no mo ye no. O man kan okuro mo se Dame and a request meeting.
Afe by was saying.
Afe mu say po adomo kire a show a screenshot of we no a request for meeting no. Afe do ko gina court no or say ono na a request first meeting with Attorney General. Na or requesting meeting because no person Oshiano na o church in Simu Chen said they be ya or betting Samasi.
Na ese kenya boni.
O de me ba.
Okay.
Go down. O say go fredame ehia without your lawyers. Na ebu emra so say obi wo e wa asem wo court na other side dey pesi ehia na ese ne lawyer e wo ho ansa na yetime ehia no. Enti dame abu mra so eno ka ho kranti NDC for say Dame on resign. But today, you have told the court, say, I wo and I would to suffer Dame near the kind, so person wouldn't share without your lawyer. And Adame Koko Shiao. And I say, why been papa? I didn't the one country lawyer say, or no, and Fred Dame, now only in Kushia.
Okay.
But to suffer Dame, a Shiano, without your lawyer.
Inti on say Japan ujiri di enye.
Debi
because story say dun ketia ebeka na bonti Japan ka kire.
Yes.
And say dun ketia abekasa. Te say comical you know about beye. And e court no. Japan abekasa ono and what to no nsa frɛ
on the to no nsa
ɛfɛ attorney general
so panichew
obeso ohia no
in fact odana say attorney general na boa no ma na nya bail
enti sisi on say ka kyerɛ mo say enema ekoso wa bonte de say diketa mo ye no ye no de court enyi
yes
on say asem no one file no an court
yes
okwa asem no kre
akoka no kre
ama before then na wo kana plan what so expose no we team some we say when I requested
meeting first
ye ka kyerɛ mo say go freda me asem na aba no monto mobo
yes na onim
no kra be daddy
onim ne ntia request or introduce ne ho say eye me Richard Jakpa Justice Yoni Colon the Supreme Court judge ni nua
enemy
na me pese me hia wo
yeah no kra so
and I say says what can say dia eno de sa wo pese wo hia me wo nua no ho de a me arrange through nua no na me hia wo
okay
enti ansana obehia Jakpa no odikan
eka kire Justice Yoni Colon
obi afrɛ me say ni nua no no pese wo hia me wo ho
enti de ba be hia wo
enti e ampa na o say ai o ni mu bi asan na say ndi ko hia wo na me ko hia wo
let's say
na eyobu a
exactly
go freda me
exactly
ma Justice Yoni Colon enti no ko ni fi ekohia Richard Jakpa and na ho na me question e eba say enti adenti and na Supreme Court judge no Jakpa Ndra according to the court proceedings no say ohia attorney general ho empre 9 ni nyina wo Colon fi e bi 9 pm e bi 11 pm e bi 10 pm empre 9
wa ko mi pa so e bi no mo e wo ho mo ka say na ko so bi 10 pm ni ade yesre mo e bi a wo ye teacher ni ko aduma 8 anapa 8 to 2 no wapon e bi a wo nye extra classes it opon a ubeko fie but don't forget teacher di bo so a wo ye extra class be 4 obedru fie na akobo no
yeah
Ghana ye won to meet somebody at 10 pm and yet out of ordinary
no especially in one kind of Kumasi
yeah the one kind of Kumasi I feel no bin pa no ko 1.5 o'clock
yeah
obeto traffic mo be say this obi shia na no wotwe abo
in fact obi correct me pon trade because otu a traffic obeshi fu
enra bi yes
bon nan ansa na watu so
ko kutu aso
enti godon obu a papa no
obuo
owoma Supreme Court judge no ene ma okokosia no na me masem ne say e ba ne sen na Supreme Court judge asem wo court na a criminal case na ye di asem no afiase na wo tena asem no so wo fie anadwo 10 pm empre 9
okay kwaku
na odi o Jakpa say attorney general ka kire no oni no agree e wo Supreme Court judge no efie ho say odene ho beche no enti omoa no odi Jakpa's account na make you
okay
enti omoa ono attorney general no na onfa ayi ato Forson entum na obeja no enti so omane adanso de ni wi a obe submit ayi submission of no case na wa mano no prosecute no waja no but eduru ho no wanye nti wanye ni nti eno oka wo court say and oni me ahia na do oni me isi no the tape ya ba abontin it's attorney general enta no le prosecute ne dia aka Jakpa no yidin
aka media to force into
mu aka wa mekasa
we team so okoton to force
sa no person chere he's a person ordinary obi di bg free
obeton the daji kosua
no aka obeton the freedom tio when wo bra judge no akwa kosi attorney general mu fie ena na bopo say mo beboa no according to Jakpa na ni account na mefa
yes
mo beboa no na de atofo sia atum na wagyawo
na what did you abonte
na de wagi wani na wo hu say ka bia case na ekọ no enya ade ye beba so no ena fe de oba abontin Ay3su me question mienu Supreme Court judge no godon ade nti no guso because has media it is said justice sewa afia sarebotwe ma men de me ginidio so timi frɛ Justice Yoni Colon wadaka mu
kwa ku bi pa cho wonti
ana wonti mi frɛ
da bo no wonti mi frɛ no da bi the Ghana judicial system no judge ntimi emfrɛ obisa da bi prosecutor
and so frɛ no
and obeso mo frɛ ne say ABI person yabodi but judge no won't to san free obi
okay and the prosecutor no can judge and say obehia justice you ni Colombia e wa dakam na and I don't 9 p.m. ni 11 p.m. no nkoma e course wo ni fie ni ntu no fresh
and say nkoma no say asema ajakpa e ka no say beye nti wahye what you say na ba bear his word against the word of Godfrey and I said the word of
Attorney General
no of the chief judge of the Supreme Court Johnny Kulendi na said who be here so bebe mu a obeba ba me de me gidi say Justice Johnny Kulendi asem no ebi ebekọ judicial council me sare me gidi LTA say ho na ebekọ amabi amako ka asem gbosa say na wo ye Supreme Court judge na say asem ba si wo busu ni say din yo wutimi frɛ wutimi di asem no ebe ka asem no bibi ye ni asem no wutimi ebe di asem no nkomo ewu fie
ama wo kyerɛ ba bi asem
no fa nko ana eti ye no de megidi say I was say judicial council they should take judicial notice of it.
Yes.
Na ABS will be a petition no say the kwan be faso no omo hwe I'm not sure say this will be petition answer because me cho bibia a reported a publication me ye frame me
wa bro obi
anko ba mane
enti we so na ade no mo me kasa wasem yi
enti ado de say omo hwe say bibia kobone a omo mfre no na omo bakwaku Godfrey Dame ese omo oba be victim office me can say krumpu
obu a woma
of respect to the elderly and people of reputation ya ukrum anya sa ekwonko
kono krankasa
ekwana npo
and because of sa premise no
yes
I almost set here and nti na ma o entertain Jakpa on the telephone
and wasan kwa nka che say ene yenko hia wa ha won sa wo bra na edia
na wo super so hia me dia won
ene me ka kire no na so wo preso a ba bi sha wo no adi fie
asem no ani
so what you see
but no asem no ani
ai na bi se de san ye nwanwa a wo se end this vote be pagana fo nyina a che say omo twa ntro ato Attorney General so
mebre
Attorney General according to Muamu Richard Jakpa ne say ono e no to no sa frey
Godfrey Dame esre ne say opposition
mewa mom na ba kana bonte say Godfrey Dame e na tata Richard Jakpa so opposition court so
I say omushia
bakwaku ba ko voice no
oh
so what dia
so according to quasiability logic any idiot can go to court but there is a note of caution. The courts do not interrogate suspicions, conspiracy theories, conjecture and rumors. They deal with facts, evidence and law. Case closed for the year. So according to quasiability logic, any idiot can go to court, but there is a note of caution. The courts do not interrogate suspicions, conspiracy theories, conjecture, and rumors. They deal with facts, evidence, and law. Case closed for the year.
Enti, when Abdul Malik Kukubako, and I'm motivating Kano, and a deputy attorney general. Try boa say almost 30 say state no start say or ye cross examination not na dance di no e di e face omo a afi na funu ne bebie amagana fu nyina hu ne bekoso enti entrance emobi antum futu ngu ani emobi a enada na asem ne de imbeba hopa me pa cho high sense for asem kan chiro said afi de Euro 2024 no aso Bola can see some pet na TV one here. Obi on one pet TV a chikwan da or crown smartphone. But do say bobo say peno be a pet TV a chikwan. Ghana should you be any. Say open smart TV. Na open sound system. I'll be sound the gum. Na commentary cost na uti dia. Oh, utsan high sense on na koto TV baby a the baby. Ubetu sikatran. Into TV pa say a year kwakoboy. Say open state of the art. Any high definition TV 4K, any QLED, any mini LED TV, and only are there 32 to 100 inches. At 100 inches in the go ye a board them one at Senior Stadium hobby.